Hi everyone. Today we will be discussing Chapter 14. Chapter 14 focuses on healthcare fraud and abuse, and we will go ahead and get started. All right, so to give you an introduction, healthcare fraud and abuse has become a front burner issue. Federally funded healthcare programs such as Medicare and Medicaid have lost billions of dollars through fraud and abuse. Private insurance companies have lost billions of dollars as well. In response to this, Congress and state legislators have passed laws to address this problem. Federal and state governments have increased their enforcement efforts of existing regulations and laws, as well as private insurance companies that have escalated their efforts to expose fraudulent claims. The increase in scrutiny has caused providers and organizations to change their methods of operation and has created new jobs that did not exist nearly a decade ago. Because HIM professionals manage many risk areas that are open to healthcare fraud and abuse, including accurate documentation, coding, and billing, it's important for HIM professionals to understand this area of law. Fraud and abuse is defined as a false misrepresentation of fact that is relied on by another to that person's detriment and is a departure from reasonable use. False misrepresentation of fact may take the form of words or conduct, including false or misleading allegations or concealment of facts that should have been disclosed. The misrepresentation is done knowingly and is not the result of negligence. The departure from reasonable use means that the misrepresentation is contrary to the proper order established by the usage in the industry. Within healthcare, fraud and abuse refers to the efforts of a healthcare provider or an organization to misrepresent the facts to a government entity or to a third-party payer so that the facts appear legal and customary in the industry and result in some form of benefit, usually monetary. The misrepresentation is not a matter of mistake, but rather a willful act or omission. Fraud and abuse requires a willful and knowing action on behalf of the healthcare provider or organization to misrepresent a fact to the government's or third-party payer's detriment. The most common forms of healthcare fraud and abuse relate to the areas of false claims and billing practices. For example, billing for services that were not rendered, such as submitting bills for exams, x-rays, and lab tests that were not delivered. Other examples include upcoding and unbundling. Upcoding involves submitting a bill for a higher level of reimbursement than actually rendered in order to receive a higher reimbursement rate. Unbundling involves submitting separate bills for each component of a procedure instead of using the proper procedural code for the entire procedure, resulting in a higher reimbursement rate to the provider. Other forms of healthcare fraud and abuse include healthcare providers' referral of a patient to a facility in which the provider holds financial interest. This is referred to as a Stark violation. A provider's referral of a patient to another provider in exchange for compensation is commonly referred to as the kickback violation. The federal government has responded to the economic threat posed by healthcare fraud and abuse by passing legislation that specifically addresses the issue and by focusing prosecution efforts by using existing legislation that was originally intended for different purposes. Within the healthcare fraud and abuse field, False Claims Act, or the FCA, which was originally used during the Civil War to prosecute individuals and organizations that supplied a union with inferior products or cheated the government outright, the FCA has now taken on a whole new use over the past 2 decades. It's used to protect the government against those who charge for services not rendered and is often used in Medicare and Medicaid contexts. False Claims Act claims are typically brought as qui tam actions, which allow private plaintiffs to sue on behalf of the U.S. government and to receive a portion of the recovered funds if successful. The plaintiff begins the lawsuit on his own initiative. However, the government may decide to intervene in the case and take over prosecution or may join in the prosecution with the plaintiff. The government may decide to allow the plaintiff to proceed with the case on his own without any form of government intervention. Typically, a plaintiff is a current or former employee of the healthcare provider or organization who has learned of the fraud and abuse and wishes to expose the activity. These plaintiffs are called whistleblowers. Whistleblowers have included physicians who have supervised labs and supervisors responsible for billing, coding, and claims processing procedures. Plaintiffs have even included individuals whose insurance benefits were the subject of coverage and payment disputes between Medicare and third-party payers. Anti-kickback statutes prohibit the offer or solicitation of remuneration, including kickbacks and rebates, in exchange for referrals of federally payable services, including Medicare services. Many states have followed Congress's lead, passing their own legislation prohibiting payment for referrals for services offered by managed care companies and private insurance companies. In the strictest sense, an instance where a physician is paid for referrals would be prohibited under anti-kickback statutes at both the federal and state level. Healthcare organizations have been prosecuted under this statute for, and among other things, acting pursuant to the terms of a partnership agreement that allowed for profit sharing and below-cost testing in exchange for test referrals that could be billed at full rates. Because the anti-kickback statutes examine relationships between healthcare providers closely, it has become customary to formalize business relationships through the use of written agreements. This formalization process has resulted in providers engaging in more arm's-length transactions for goods and services and allowing for the avoidance of impropriety. Several exceptions to the anti-kickback statutes do exist, and they are called safe harbors. Safe harbors highlight activities listed in the exceptions and will be considered legitimate practices. Those healthcare providers who question whether any individual transaction falls within a safe harbor may seek an advisory opinion from the Office of Inspector General of the U.S. Department of Health and Human Services. Physician self-referral prohibitions have also been the subject of much litigation. In response to the concerns that physicians were abusing the system by referring patients to their own services, Congress passed laws that prohibited self-referral for a number of services. Under the first law, referred to as Ch14, a physician is barred from referring Medicare patients to a clinical lab in which the physician or an immediate family member possesses a financial interest. Congress later extended the prohibition to other services so that a physician is barred from referring Medicare patients to a designated health service in which the physician or immediate family member possesses a financial interest. This is referred to as Ch2. There are several other statutes that sometimes form the basis of fraud and abuse lawsuits and even serve as an adjunct to a claim filed under one of the statutes previously addressed. The prosecution of a fraud and abuse case may involve the use of federal mail and wire fraud statutes. These statutes prohibit the use of the U.S. Postal Service or commercial wire services for the advancement of a scheme that relates to fraud. Because modern business practices routinely involve the use of the mail system or wire services, it would be fairly easy for a healthcare provider or organization involved with fraud to violate these statutes. A violation of these statutes is a felony. that's punishable by a fine of upwards of $1,000 and a 5-year term of imprisonment, or both. Other charges brought as part of a prosecution may include false statements made pursuant to obtaining a benefit or under the payment under the Social Security Act, conspiracy to defraud, money laundering, or racketeer influence and corrupt organizations. Because of the significance of the remedies the federal government may wield in a fraud and abuse case, healthcare providers and organizations have 2 additional incentives to obey the law. First, the federal government may apply the civil money penalty law to a violation. Under this statute, the Department of Health and Human Services is permitted to recover money damages for false or fraudulent claims. The healthcare provider would then be responsible to make a restitution to the government for fraud at issue and could also be fined up to 3 times the amount of damages plus an additional fine not to exceed $10,000. An even more significant deterrent to healthcare providers and organizations is the statute providing for permissive and mandatory exclusion from participation in Medicare and all other federally financed healthcare programs. This statute provides for the exclusion of a provider or organization due to criminal or other program violations. For instance, a 5-year to permanent mandatory exclusion applies to healthcare providers and organizations that have received felony criminal convictions. For misdemeanor actions, debarment from participation for a minimum of 1 year may apply. Because it is not economically feasible for a healthcare provider or organization to forego service to Medicare beneficiaries, the exclusion provision is a powerful weapon for the government to exercise. Another development in the prosecution of healthcare fraud and abuse is HIPAA. HIPAA both modifies the civil money penalty law and provides enhanced resources for the federal government to combat healthcare fraud. The civil money penalty law is modified to include penalties for actions that are specifically related to healthcare fraud and abuse, such as unbundling, upcoding, and seeking reimbursement for services that are rendered after being excluded from participation in Medicare or Medicaid. A list of these actions include engaging in upcoding, engaging in patterns of claiming medical unnecessary items of service, transferring money to a Medicare beneficiary that may influence the beneficiary in order to receive items or services, to include the waiver of coinsurance and deductibles for service, and for submitting a claim when the provider has been excluded from the Medicare and Medicaid programs while retaining ownership of a controlling interest in an entity that still participates in Medicare or Medicaid. HIPAA also has established or strengthened 4 programs to assist with fraud enforcement. They include Fraud and Abuse Control Program, which operates jointly by the Department of Justice and the Office of the Inspector General to control healthcare fraud and abuse and conduct investigations relating to the delivery of healthcare services. The second program is Medicaid Integrity Program. This program directs the Department of Health and Human Services to enter into agreements with private companies to carry out fraud and abuse protections. The third is Beneficiary Incentive Program. This program encourages Medicare beneficiaries to report suspected cases of fraud and abuse. The fourth program for fraud enforcement is the Healthcare Fraud and Abuse Data Collection Program. This is designed to create a national healthcare fraud and abuse database in coordination with the National Practitioner Data Bank. The Deficit Reduction Act of 2005 provides additional strength to combat fraud and abuse in the Medicaid program. This law changes the nature of compliance programs for some institutions from voluntary to mandatory and requires employers to educate staff concerning administrative remedies to violations of the False Claims Act. It also adds more resources at the federal level for combating fraud and abuse and provides a financial incentive to states to adopt laws that are similar to the Federal False Claims Act. The ARRA Act strengthened the HIPAA regulations in 4 ways. First off, the ARRA specifically states that business associates are covered by the HIPAA security rule, including the administrative, technical, and physical safeguard requirements, making them all subject to civil and criminal penalties for not complying with the terms of the security rule. Second, it clarifies who can be held accountable for wrongful disclosure of protected health information. Under ARRA, both individuals and healthcare entities may be prosecuted for wrongful disclosure of protected health information. The ARRA also addresses noncompliance due to willful neglect. And finally, the ARRA addresses the civil money penalty provisions of HIPAA, specifying that the restitution provided to the government due to healthcare fraud and abuse may be used to fund the Human Health and Services enforcement activity. There are several law enforcement agencies that share the responsibility to prosecute healthcare fraud and abuse. One of the most prominent agencies is the Office of Inspector General of the Department for Health and Human Service. The Office of Inspector General is authorized to conduct civil, administrative, and criminal investigations of fraud associated with the federal Medicare and Medicaid program. In keeping with its responsibilities, the Office of Inspector General provides guidance to healthcare providers on how to comply with applicable local, state, and federal laws and regulations. The Office for Inspector General has experienced considerable success in the last decade by launching several different initiatives whose goals was to recover alleged overpayments made in connection with specific types of improper claims. The Office for Inspector General has a strong emphasis on the approach and has not been without criticism. Some have claimed that the subjects of these initiatives committed honest mistakes or at most negligence and should not have been prosecuted, but instead educated concerning the proper manner in which to submit claims for payment. The Department for Health and Human Services has responded by instituting and emphasizing preventive programs to be operated by the CMS. Examples of such programs include the Correct Coding Initiative, the CCI, which has been designed to promote national correct coding methodologies. Another program is the Payment Error and Prevention Program, the PEPP, which has been designed to reduce the Medicare payment error rate. CMS also coordinates with the Office of Inspector General to publish numerous guidance materials that are available through the CMS website and explains and clarifies its rules and regulations. The law enforcement agency with the widest responsibility to investigate healthcare fraud is the Federal Bureau of Investigation, the FBI. In contrast to the other agencies that we described, the FBI possesses the authority that extends beyond the jurisdiction of a particular governmental program. The FBI may work jointly with the Office for Inspector General, as well as CMS and the Postal Inspection Service, or it may act on its own based on complaints received through calls, letters, or visits from members of the public. In addition, the FBI may investigate due to efforts of a whistleblower acting pursuant to the False Claims Act. Other law enforcement agencies and their areas of responsibility include the Postal Inspection Service, responsible for investigating fraud scheme involving the U.S. mail system, and the Defense for Criminal Investigative Service, the DCIS, which is responsible for investigating fraud schemes committed against the military's health insurance programs. Investigations of healthcare fraud typically extend over several years and may involve interviews with the whistleblower, members of the public, and possibly the healthcare provider or organization itself. Documentation may be obtained through the use of subpoenas and search warrants, and institutions other than the healthcare provider, such as CMS and billing services, may be asked to supply further documentation. As a health information professional, if you are confronted by a law enforcement agent with a search warrant, you should remember that the police officer has a duty to cooperate with the agent, but at the same time has the obligation to notify a provider or organization's legal counsel of the request presented by the agent. Although it may appear difficult to balance the duty and obligation, it's imperative that as a professional you do so. Upon notice, legal counsel will assist the professional in determining how to respond cooperatively to the agent's request while including what to say and what not to say. Until legal counsel has provided advice or has arrived on the premises, the HIM professional should cooperate with the agent's request to gather specific records and information while not answering any additional questions. Upon completion of investigative processes, the law enforcement agency will work with the local U.S. Attorney's Office to pursue prosecution of healthcare providers or organizations that are suspected of the wrongdoing. Both government offices will determine whether to proceed with a lawsuit, including which statute forms the basis of the claim against the healthcare provider or organization. To avoid going to trial, those same government agencies may craft a financial settlement agreement with those suspected of the wrongdoing. Compliance has been a part of health information management since the very start of the profession. Health information professionals have worked to comply with voluntary accreditation standards, federal and state laws and regulations, institutional bylaws and rules, and professional codes of ethics. The effort to comply with these external forces became even more complex with the advent of the third-party payment systems and government reimbursement. With the focus on healthcare fraud and abuse intensifying and the advent of implementing rules addressing privacy and security under HIPAA, compliance is now a formalized part of health information management. Compliance is defined as the efforts to establish a culture that promotes prevention, detection, and resolution of instances of conduct that do not conform to applicable local, state, and federal laws and regulations. A compliance program ensures the establishment of an effective internal controls that promote adherence to the applicable local, state, and federal laws and regulations and the program requirements of federal, state, and private health plans. Compliance programs may be grounded in an ethics-based approach. Under the ethics-based approach, the healthcare organization decides that it wishes to conform to local, state, and federal law and regulations because it is the right thing to do or because a cost-benefit analysis reveals it would be a sound business practice. The ethics-based approach encourages good behavior and is in essence a voluntary form of improvement. This approach demonstrates to employers and the community as a whole that the organization is committed to responsible corporate conduct. So the establishment of compliance programs can be performed from an ethics-based or a minimum legal requirements approach. The ethics-based approach encourages the good behavior and is in essence a voluntary form of improvement, which we previously mentioned. Under the minimal legal requirements approach, however, a healthcare organization decides it will conform to local, state, and federal laws and regulations because of the fear of punishment in the event of non-conformance, the so-called fear of getting caught. Because the conformance standards are externally imposed, the motivation under this approach is to avoid or minimize penalties or punishment. Under either approach, the result is that healthcare providers that implement effective compliance programs reduce their exposure to civil damages and penalties, criminal sanctions, and administrative remedies. The provider also benefits through a greater ability to assess and improve the efficiency, effectiveness, and quality of patient services. The healthcare provider develops a centralized internal mechanism for distributing information on healthcare statutes, regulations, and other program directives. as HIM professionals can assist the healthcare provider's efforts to ensure compliance by focusing on strengthening the documentation processes for patient care. They could also ensure that diagnostic and procedure codes are assigned appropriately and manage health information responsibly. The Office of the Inspector General of the Department of Health and Human Services has released compliance program guidelines for hospitals, laboratories, long-term facilities, hospice, home care organizations, and physician offices. These guidelines are not actually compliance programs, but instead provide basic procedural and structural information for healthcare providers and organizations to use in tailoring a compliance program to fit their own culture, structure, and processes. These compliance program guidelines are highlighted on this slide. It includes 7 key concepts, key elements, and they are written standards of conduct and policies and procedures, the designation of a chief compliance officer to oversee the program, regular effective education and training programs for all effective employees, a process for receiving complaints of possible violations, development of a system to respond to allegations of improper or illegal activities and enforcement of appropriate disciplinary actions through well-publicized disciplinary directives, audits and other evaluation techniques to monitor compliance, and 7, being the investigation and correct action of identified problems. In addition to voluntary processes, compliance can also take the form of a mandatory process. The red flag rules issued by the Federal Trade Commission is an example of a mandatory compliance process. The term red flag refers to the warning signs of identity theft. The red flag rules govern most healthcare providers and institutions and requires those providers and institutions to create prevention programs to identify, detect, and respond to patterns, practices, and activities that could indicate identity theft. With the passage of the Deficit Reduction Act in 2005, entities who receive $5 million or more on an annual Medicaid reimbursement must educate their employees using handbooks and written policies about the administrative remedies available for violations of the False Claims Act and any corresponding state laws. This requirement alone changes the practice of corporate compliance from one of voluntary nature to one of mandatory nature. Corporate integrity agreements, or CIAs, are financial settlements that are written agreements that specify the rules of conduct to be followed to remedy the fraud and abuse found, plus any monitoring and reporting requirements. These agreements differ from a corporate compliance program in that the compliance program is an internal, not an external document that is adopted by the healthcare entity voluntarily as opposed to under the direction of the government. Corporate integrity agreements can be more stringent and expensive to implement than a compliance program. For these reasons, many healthcare entities place great emphasis on compliance programs because the risk of being subject to a corporate integrity agreement outweighs the risks that are associated with adopting and operating a compliance program. Whether part of a compliance program or operating outside the program, there are some healthcare entities that have employed technology as a means to combat fraud. Most of this technology exists in 2 forms, either advanced analytic software for use in the National Health Information Infrastructure and automated coding software. Advanced analytic software allows multiple parties who operate within the infrastructure to examine data to detect fraud. Automated coding software assigns the correct code based on official guidelines and reporting rules that are programmed into the software. These codes are assigned after evaluation of a patient's clinical data that is stored electronically. A coding professional or clinician then reviews the automated assignments and edits as necessary, with more editing needed in instances where the clinical encounter is complex or the coding software is not highly sophisticated. At this time, we have completed Chapter 14, focusing on healthcare fraud and abuse. I encourage everyone to take the time to review this chapter and read it. If you have any questions, please feel free to reach out to me. Thank you.